Good day, Crime Talk aficionados. We have a great show for you today. First, the judge seals the proposed jury instructions from the defense in the Bryan Kohberger matter. What's the big secret? Karen Reed trial update. We have a update on the Lori Vallow conviction from yesterday. An update on the Susan Simpson's case. Will the husband get the indictment dismissed? That California judge was convicted. Don't jump to conclusions. It will get you arrested. We have this day in legal history. And wait until you hear our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started today, remind you to go to CrimeTalkSearch.com. Sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone here in the United States as your heart desires. The background report will literally be prepared while you wait and then emailed to you, and you can even get updates if information changes in the future. The report's going to include all types of information related to phone numbers associated with an individual, emails, social media presence, whether they're married, divorced, do they have a criminal history. Anything you want to know about somebody is going to be in that report. So go to CrimeTalkSearch.com, sign up for that background subscription service today. You'll be happy that you did. All right, let's go ahead and open the record for April 23rd, 2025. And first, on the Bryan Kohberger matter, what is the big secret? All right. We told you the other day that the defense filed their proposed jury instructions under seal. Then the state says, well, we're going to respond to the state's sealing of their proposed jury instructions because, well, they filed it under seal, so therefore we will as well. And then the judge issued an order that says, based upon the state's motion to seal, the state's response to the defendant's proposed jury instructions filed, the court does hereby confirm and order that it is exempt from disclosure and sealed. What is the big deal, ladies and gentlemen? I don't get this. All right, let's quickly talk about jury instructions. I have here, this is what they call the Colorado Jury Instructions Criminal. Okay, the jury instructions have developed over many years. And then finally somebody got smart enough and said, hey, why don't we do these all the same and we'll put them all in a book. And we'll even, you can download them. You can go to the website. You can do what you need to do with it so that the judges have them and everybody's working for them. There's a committee of judges and non-judges, attorneys that go through and say, this is what the elements are. These are the instructions that we like based upon case law or what the legislature has done. And like I said, it's a 2-book volume, right? You get all the introductory responses, right? You hear all the judges read everything that sounds so well polished. Well, they're cutting and pasting it, ladies and gentlemen. So all the jury instructions are pretty much standard, right? Orientation when you first show up, culpable mental state. Then we go through all the offenses. You can get the jury instructions for, let's just start, culpability based upon behavior of another. Crimes of violence, sentencing enhancement, interrogatories, murder, manslaughter, homicide, assault, similar offenses, kidnapping and related offenses, unlawful sexual behavior, human trafficking and slavery, stalking, other offenses against pregnant women, arson, burglary, robbery, theft, trespass, theft of sound recordings, you name it. If there's a crime for it, they come up with it. All right. All the presumption of innocence types of things, all the definitions, if they're not defined in the statute, and they're meant to be, they are in the jury instructions. There's no secret, ladies and gentlemen. So I don't get what is the big secret that the defense says we are proposing these jury instructions. First of all, they're 4 months out from trial. All right. Trial is supposed to start in August. I could submit any potential jury instruction that I wanted, but it would all be subject to the evidence at trial as to whether you actually get the jury instruction. Say, for example, I want to submit a self-defense instruction. I may not think that it's a good self-defense instruction in the sense that I think I'm going to get it, but I'm going to put it out there because I have to list my possible defenses, right? So if I was Bryan Kohberger's attorneys, of course, I'd say, well, I got an alibi right? Then I would say, I didn't do it, but if I did, it was self-defense. And maybe then I'd include lesser included offenses that, wasn't a burglary. I didn't go in there, with the intent to commit a crime therein. All those different theories. It means nothing, though, unless and until the evidence comes out. So let's say, for example, I have a case where I want to have an affirmative defense of self-defense. The only way I get that evidence is if normally the defendant gets up and testifies and said, yeah, I was there. Guy came at me. I was in fear of death or serious bodily injury, and therefore I fired the gun and, killed the deceased. Okay. I would be entitled to that jury instruction. But if there's no evidence of self-defense, you don't get the instruction. And you must present a mere scintilla of evidence to be able to get the instruction. All right. All the instructions come from the standard books. I don't understand what's the big secret. All right. Now there's a thing that can be submitted at the end of the trial. Okay. And it's called a defense theory of the case. And most judges will say, I don't want it unless you decide you want to give it. And you don't have to really give that until literally the case is over. I'm not a big fan of the theory of case defense because, by gosh, if the jury doesn't know what my theory and theme is by the time we get to jury instructions, I've probably done something wrong, right? If you can't figure out, ladies and gentlemen, this is a case about self-defense. By the time we get there, you don't need it in writing saying this is the defense theory of the case is that he acted in self-defense. Ridiculous, in my humble opinion. The only other thing I could possibly think of what the big secret is that the defense is trying to submit a bunch of instructions, trying to negate a mental state based upon some of these various characteristics that the court has said are not relevant as it relates to his autism, various other quirks that he may have. I don't see why or how that comes into play. Even if we're talking about instructions in the Bryan Kohberger case, not just the standard stock instructions, but like death penalty instructions about the mitigating and aggravating factors that the jury has to consider, they're all standard in the book anyway. Every state's got one of these as well. It used to be they wouldn't update these for like 5 or 10 years, but now they update them every year. I get a new book, and for some reason we get 2 or 3 copies every year because, well, we have multiple attorneys in here. We want to make sure you have it, but now all the young attorneys access them on the internet. So I guess I just don't understand what is the big deal so that now the defendant's proposed jury instructions are super, super secret, as well as the state's response is super secret just because the defense was. I think we'll hopefully be able to see this rather quickly. The judge will rule on it, and the judge's ruling is going to say, well, these are great. Other than standard instructions, we'll wait and see how the evidence comes out at trial. I just don't get what the big secret is. I swear, you go to any other court file in America, and if you want to see what's been filed, you should be able to have access to it. I don't know what the heck you guys are doing there in Idaho, but you think everything you do is super, super secret, and I just don't get it. And then when it gets released, it's no big deal. At least the Judge Hippler in this case, has been much, much better than, for example, Judge Woods or the judge in the Lori Vallow and Chad Daybell case, where I've never seen anything like that, where the case was literally tried in secrecy. Next on the docket, Karen Reed. So Peggy O'Keefe, the mother of deceased former Boston police officer John O'Keefe, took the stand this morning in the second Karen Reed murder trial taking place there in Massachusetts. Now, obviously, Miss Reed is accused of hitting and killing John O'Keefe, her boyfriend, with her SUV back in January of 2022, and then leaving him to die in the snow. Now, O'Keefe was a Boston police officer. And Miss Reed's defense said that they believe that somebody else killed Officer O'Keefe and that Miss Reed is being framed. Anyway, the mother, Peggy O'Keefe, became quite emotional talking about her family. Her daughter died before John, and he took his sister's children when the parents passed away. She then testified about learning that John had been found dead in the snow. She indicated how he was so bruised up, his eyes were closed. Peggy O'Keefe said about seeing her son at the hospital. Now, normally in a death case, I used to see it a lot more But they would put a family member up and they would show the picture of, do you recognize this person? Yes. Why? Because they have to show that the person is now dead. Normally, you get that from the coroner to say this is a person, they were alive, and now they're dead. But Mr. Brennan decided to put the mom up. Nice touch, Mr. Brennan. Personalizes Mr. O'Keefe, humanizes him, and it gets in the stuff about how he was taking care of his dead sister's children. Nice touch. Anyway, earlier today, Carrie Roberts, a friend of John O'Keefe and an acquaintance of Miss Reed, testified about the taillight on Miss Reed's SUV. Roberts, Reed, and Jennifer McCabe had gone to O'Keefe's home to look for him. Roberts testified that Reed noted that the taillight was damaged. The piece was missing, she testified. Do you think I hit him? Do you think I hit him? Roberts said that Miss Reed had asked. Roberts' testimony then turned to when they found O'Keefe's body in the snow outside of the home in Canton where Reed had dropped him off the night before. He was covered in snow, Roberts said, turning quite emotional when she was on the stand. She also testified about how she tried to do chest compressions when she saw Mr. O'Keefe lying on the ground. Now, Roberts also described how she went to pick up O'Keefe's parents to bring them to the hospital. And then there were a couple of other witnesses this afternoon as well. The defense keeps going off on, prior misstatements, but the people aren't really making prior misstatements. But I guess I've done it. You got to do this sometimes if that's all you've got. Well, isn't it true? You said the road was windy. Well, today you said the road had a curve. That's different than windy, isn't it? I mean, just getting into little minutia, really of no relevance. I don't think the defense has scored any potential big hits, so to speak. But remember, you're not going to get a strikeout home run. I guess get a home run on every witness. It's like a jigsaw puzzle. This witness provides this piece. The next witness provides the next little piece, and you put it all together. By the time you get to closing, ta-da! You have your puzzle, and it's probably going to show Karen Reed hitting Officer O'Keefe. And we'll give her the presumption of innocence. We'll see. We're starting to get into a bunch of the phone evidence that's going to be very, very interesting as well, because that stuff doesn't really lie. It can't be manipulated. And we'll have to see where that goes throughout the trial, as it'll take several witnesses to get there. Also in the Karen Reed case, a man is facing charges after police say that he refused to exit the buffer zone surrounding the courthouse where the second trial of Karen Reed was taking place. This guy, Bao, B-A-O, Nguyen, N-G-U-Y-E-N, of Arlington, was lingering and filming in the buffer zone outside the Superior Courthouse there and refused to leave despite several warnings from police officers. Mr. Nguyen was eventually arrested for violating the order after several requests came from the police. Now, the judge had ordered a 200-foot buffer zone remain in effect for the second trial of Miss Reed, and that it could be extended to include the area bounded by Bates Court, Bullard Street, Ames Street, and Court Street. The buffer zone was put in place at the start of this trial to keep demonstrators a distance away from the courthouse. Now, Mr. Nguyen is scheduled for an arraignment in the Dedham District Court on Tuesday. I don't know. I already think the prosecution, some people don't like Mr. Brennan. I kind of like his style. He's calm, relaxed. The defense, make your point, sit down. That's just me. Get up just to ask questions. Defense, you're supposed to be asking leading questions. Most of the questions today were what, who, very open-ended questions, right? No, that's what the prosecution's supposed to do. The judge said at the end of the hearing today that she was a little frustrated by the pace of things and would like to pick it up. I think she was talking about the defense. Let's move it along. We're not doing a deposition here. We're doing trial. Make your point. Sit down. All right, next, the Lori Vallow trial. We brought it to you live yesterday. That's right, Lori Vallow. What do you want to call her? Doomsday mom, serial killer, whatever. She was convicted last night of conspiring to kill her fourth husband. Now, obviously, Lori Vallow is already serving multiple life sentences for the murder of her other two children, as well as her fifth husband's new wife, Tammy Daybell. You know, she gave it the old college try. It didn't go well for her. After the trial where she was convicted, they were going to go to the aggravating phase for the jury to determine that there were aggravating factors, and that will be considered at sentencing. But Lori Vallow stipulated that this was, in fact, a dangerous crime, that there was loss to the victims and things of that nature. I'm assuming she did that so that the victims' family members wouldn't have to get up and, talk, and she wouldn't have to face them. Either way, she knew the game was over. She has her other trial for the attempted murder of Brandon Boudreaux, her niece's husband, several years ago. They've since divorced, and we'll see how that one goes, but she intends to represent herself as well. Next, we have an update on the Suzanne Simpson case down there in Texas. So a judge has delayed his decision of whether to throw out the murder case against the husband accused of killing his wealthy Texas realtor wife, whose body has yet not been found. So Brad Simpson was arrested 3 days after his wife, Suzanne, was spotted by a neighbor in a late-night argument with him outside of their home in San Antonio, Texas. The couple, apparently screaming, the altercation marked the last time the mother of four was seen alive. Now, Brad has since been indicted on first-degree felony murder charges and aggravated assault with a deadly weapon causing serious bodily injuries. Now, those charges carry a significant maximum penalty of life in prison. He's also facing charges of tampering with a corpse, as well as 2 counts of tampering with physical evidence and possession of a prohibited weapon. However, on Tuesday, the defense argued for a judge to declare his indictment invalid, which would prevent him from standing trial on new charges. In the hearing, Steve Gilmore, the attorney for Brad, argued that the judge, Perez, that the lack of details in his client's indictment violates his constitutional right because he is not able to prepare a defense. Gilmore also withdrew portion of his original motion filed back in February and instead shifted to focus to a specific paragraph. Now, the paragraph in question is the paragraph that states the indictment was too vague regarding how the state believes Brad caused his wife's death. In the original indictment handed down by the Bexar County grand jury, Brad allegedly killed his wife by a manner and means unknown, later concealing both the power saw and an automatic weapon after her disappearance, knowing that an investigation was in the process. The attorney argued that Brad has the right to be informed of the nature and cause of the accusation against him through both the United States and the state constitution. Now, the lead prosecutor in this state completely disagreed, arguing that the state doesn't need to prove how Brad killed his wife, only that he intended to do so and ultimately caused her death. Additionally, the prosecutor stated that a medical examiner determined Suzanne's cause of death is not required to move forward with the prosecution of her husband for the crime. The law doesn't reward people who are disposing of the bodies of their victims, the DA argued. The case law is clear that the state does not need to prove how Mr. Simpson murdered Suzanne Simpson. Anyway, the judge is set to issue his decision on April 29th. I don't really think it's a big deal just to say that you killed it. I mean, to wit, they always say to wit, a deadly weapon means unknown. That goes to the weight of the evidence at trial. I don't see it as a motion to dismiss the indictment, but we'll have to wait and see. Anyway, in this particular case, Suzanne, who worked for Nick's Realty Company, went missing after attending a party at the Alamo Heights neighborhood. The following night, Suzanne's friend, who got in touch with the police to report her missing, followed by a voicemail left by Brad almost 15 minutes later. Police believe Suzanne died on October 6th of 2024, the last time that she was seen alive, as they have not found any evidence of life from her cell phone records, financial records, family, friends, or coworkers. Now, in the arresting affidavit for Brad's arrest, the Olmos Park police described his movements on the night his wife was last seen alive to the next day when she was reported missing. Now, a neighbor told police he'd heard a couple arguing from his window on the night of October 6th. It was a Sunday, and the neighbor witnessed the pair in a physical fight, with Brad grabbing her upper torso area to gain control of her body. After the alleged fight carried on for several minutes, the neighbor said he went outside with a flashlight to look for the couple. He then reportedly rushed back inside after hearing screams coming from a wooded area across from the house. About an hour later, he claimed that Brad took off in his truck before returning to the home a few hours later. all according to the arrest affidavit. Now, the couple's youngest child told their school staff that her father hit her mother in the face and he probably pushed her into a wall on the same night, resulting in an elbow injury. The child also allegedly told the school staff that her father had taken away her mother's cell phone before turning it off. Police were able to spot Brad on some security footage with 3 white trash bags, a heavy-duty trash can, an ice chest, and a large bulky item wrapped and secured in a blue tarp, held down by a firewood rack in the bed of his truck. I wonder what that could be. Anyway, it was discovered that he had bought 2 bags of cement, a construction bucket, a box of heavy-duty trash bags, Clorox disinfectant spray, and insect repellent with cash from a nearby Home Depot. Before he made his purchase, he asked an unknown man in the parking lot for directions to the nearest dump near town. Later that morning, Simpson's truck was spotted at a gas station with a white trash bag missing. However, the blue tarp, firewood rack, and trash can were still in the bed of the vehicle. When he was seen picking up one of his children from school, the bed of his truck appeared to be clear and the blue tarp and metal firewood rack gone. He was then spotted on a security camera less than an hour later, washing and cleaning his truck's driver front side and rear left passenger side at a car wash. And then on October 9th, Texas Rangers found a ground level burn site at the Simpsons property and recovered a burnt laptop and 3 cell phones belonging to Brad. All completely innocent excuses, ladies and gentlemen. Well, needless to say, Brad was ultimately arrested in connection with Suzanne's murder, though her body remains missing. Now, the affidavit alleges that Brad did not appear surprised at the time of his arrest, nor question why he was apprehended, right? Most people usually ask, why am I being arrested? Not him. Anyway, detectives said his cold behavior was a contributing factor to the arrest. They said they believe Brad intentionally and knowingly caused the death of his wife. Well, his attitude may come in. How did he act? He was calm. Probably not that much relevance. Anyway, investigators eventually found Susan's DNA on Brad's power saw. The DNA was reportedly part of the evidence presented to the grand jury. Brad is currently being held in the Bexar County Jail on a $5 million bond. If the judge throws out the indictment, the state can then re-indict him at a later time. What can you do? Ladies and gentlemen, all completely innocent conduct. Have a fight with your wife, hear her screaming in the woods, drive away, go to Home Depot, buy a bunch of stuff with cash. One of the trash bags disappear. Your wife's DNA just happens to be on your saw. Completely innocent behavior. And then your own kid's throwing you under the bus. Brad Simpson's he's got a tough case ahead of him. I don't think his indictment's going to get dismissed either. But even if they do, what does it matter? It's just a delay tactic. They'll re-indict him yet again. Well, let's do a follow-up on that California judge that was accused of killing his wife. Well, now it's official. He killed her. Jurors convicted a Southern California judge of second-degree murder on Tuesday for fatally shooting his wife while the couple argued and watched television at home. Now, the Orange County Superior Court Judge Jeffrey Ferguson, now this guy's 74 years old, so whatever he gets, it's basically a life sentence. He was on trial for the 2023 death of his wife, Cheryl, in their Anaheim Hills home. Now, Ferguson took the stand in his own defense, admitting to shooting his wife, but saying it was an accident. Jurors reached their decision Tuesday afternoon, a day after deliberations began. And after the verdict was read in court, Ferguson was given a moment to hug his son before he was handcuffed and taken into custody. He was also found guilty of felony gun enhancement charge and faces a maximum prison term of 40 years to life. Sentencing will be held June 13th. Now, the verdict comes after a previous jury was deadlocked back in March, and the Los Angeles County Superior Court Judge Eleanor Hunter declared a mistrial. Now, Hunter was overseeing the case to avoid a conflict of interest with the Superior Court in Orange County, where Ferguson presided over criminal cases until he was charged with this particular case. Now, prosecutors said that Judge Ferguson had been drinking before he made the gun-like hand gesture toward his wife of 27 years during an argument about family finances, and they'd had during the dinner at a Mexican restaurant on August 3rd. Prosecutors said the argument continued at home while the couple was watching Breaking Bad on TV with their adult son, and Cheryl Ferguson chided her husband to point a real gun at her. He did. Then he pulled the trigger, prosecutor said. Ferguson testified that he was removing the gun from his ankle holster to place it on the table and fumbled it, and it discharged. Immediately after the shooting, Ferguson and his son both called 911, and Ferguson texted his court clerk and bailiff saying, "I just lost it. I just shot my wife. I won't be in tomorrow. I'll be in custody. I'm so sorry." His son Phillips testified to tackling his father to wrestle the gun away after the shooting and perform CPR on his mother. Ferguson spoke with police outside of his home and once again when he was in custody and was seen on video sobbing, saying his son and everyone would hate him in the video. He said he killed his wife and pled for a jury convict him. Authorities said they found 47 weapons, including the gun used in the shooting, and more than 26,000 rounds of ammunition at his home. And they also said that he had ample experience with trainings of guns and firearms and ammunition. I mean, why is that relevant at a trial that the man has 47 guns? It sounds like a good start to me. Good start of a good collection. 26,000 rounds. Is that all? I didn't even know you could buy that in California. I thought they were all banned or something, or they make it difficult. Jeez, good thing he was a judge. Next, don't jump to conclusions. It can get you arrested. A Florida man has wound up behind bars after he was busted for allegedly roughing up an 11-year-old girl who he thought egged his home. That's right. This incident occurred in Tampa, Florida, an apartment complex, and was partially captured on video. Take a look at this. The suspect, Marius Mutu, is seen pinning the girl to the ground outside the building as she screams and cries for help. The girl swears to God she didn't do anything wrong, but her words fall on deaf ears as Mr. Mutu won't let her move. At one point, the woman recording the video orders Mutu to get off of her. Then you hear a man tell Mutu to remove his hands from the girl, followed by someone rushing up to help the kid. Then the video goes out. Anyway, the sheriff down there said that Mutu chased the girl, knocking her to the ground and restraining her until all the adults intervened. And then the police were called. The deputies interviewed Mutu, who allegedly said the apartment had recently been egged a couple of times, and that's why he pounced on the girl, believing that she was the culprit. Well, Mr. Mutu was arrested and booked into the county jail on suspicion of battery and false imprisonment. Apparently, there's no other evidence that the young 11-year-old girl was throwing eggs at the apartment. Oops. Yeah. Be sure you're going to do something, that something happened before you go do it like that. And call the police. You can't engage in vigilante justice, ladies and gentlemen. Think this is the Wild West or something? No. Next in the docket, this day in legal history, April 23rd, 1789. The Judiciary Act of 1789 was debated, and it later established the federal court system, a cornerstone of, obviously, our U.S. legal structure, right? Only the Supreme Court is specifically mentioned in Article 3 of the United States Constitution, and it says that they can establish inferior courts. Those would be the Court of Appeals, as well as the district courts that you hear so much about these days. It's all just a matter of legislation. The jurisdiction of the federal courts could change at the whim of Congress. Nobody's really updated it that much, at least since 1789. Then on April 23rd, 1896, the Supreme Court hears Plessy v. Ferguson, later upholding the separate but equal, obviously a pivotal segregation law, ultimately, not overturned until the 50s. But 1896, Plessy v. Ferguson, separate but equal was okay. No, wasn't. Should never have been. Anyway, then on April 23rd, 1946, the U.S. joins the International Court of Justice, influencing international diplomacy and legal frameworks. On this date in 1971, the United States Supreme Court rules in Cohen v. California protecting offensive speech. That's right, ladies and gentlemen, offensive speech is protected under the First Amendment. Just because something offends you doesn't mean you get it banned. No, only true threats, ladies and gentlemen, only true threats. Offensive speech? No. Protected. You don't have a right to not be offended. And then on this date, April 23rd, 2007, the United States Supreme Court hears Morris v. Frederick, later limiting students' free speech in school settings. That's right, kids. In parents' loci, you go to school, school takes over as your parents. Also a little scary as well. Anyway, kids, you don't have as much rights as everybody else does once you're in school because, hey, you're a kid. You don't know what is right for you anyway. And then finally today, our dumb criminal of the day. I don't know what to say about this young woman. The fact that she has children and they have not been taken away sooner is obviously a little surprising to me, and hopefully it will be to you as well. Like I said, so this unidentified woman explains how she doesn't want the children. They're interfering with her partying. Only thing she's thinking about is men. And maybe, social services would like to take the kids away, and she'll be back when they're 15 when they can take care of themselves. Take a listen to this, ladies and gentlemen.
No, ma'am. I am baffled by the accusations that are made against me. That's the thing with society. Society has changed so much. Back then, my parents used to leave me at home all the time while they go have fun. Did y'all lock them up? No. Everybody keeps saying I'm a bad parent because it's only one of me. The daddy ain't there, as you could tell. We black. My neighbors called my phone while I was with my new man. I had just broke up with my other man the day before, so I'm not talking about him. So if he see this, I'm not talking about you. CPS ended up calling me while the police are there, and they trying to trick me into coming home. My neighbors called me, telling me that. I don't even know who called me. I was drunk. You feel me? But one thing I'm not gonna do is go turn myself in to the police while CPS there. If y'all want the kids, take them. I don't want them. And when I tried to give them up, y'all wouldn't take them till I got to do child support. I'm going to get an abandonment charge. Y'all don't do that to everybody else. Y'all just go in while they all happy with their family. Y'all go in and take the kids. Take mine for free, baby. I'm not doing that. And then y'all keep coming around trying to look for me to do news videos. Or if you could do a clip, y'all better not call the police. 'Cause I know one thing. Like, what am I supposed to do? Take my kids out while I'm going to go party? Regardless of what it is, I'm going to go party. So y'all want me to take them with me or not? No. They going to kick me out. They ain't even going to let me in the club. My main focus is men. Men. Not no kids. Make it make sense. I'm only 30 years old. I'm tired trying to live my life. Y'all irritating me. I'll probably go get them kids back when they like 15 or whatever age it is for them to stay home by themselves. They only 6 and 7. They can't cook on the stove and then they can barely reach it. So what are y'all afraid for? I got them in there asleep on melatonin.
Does that not just leave your head hurting? People like this exist, ladies and gentlemen. You got to get a license in a lot of places to get a gun, to catch a fish, drive a car, but anybody can be a parent. It's kind of scary. All right. Well, it's fundamental right. Can't keep people from having kids, no matter how irresponsible they are. All right. That's all we have for today. Hope you enjoyed the show. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.